go ahead and get started and announce our special speaker, Thomas Baker with Canon.
Thank you, Sherry.
Thomas comes to us from Seattle and has been in New York, though, for the last 20 years. He is a specialist in the legal field, and we met Thomas through Canon's vertical market training and thought, boy, wouldn't it be great if we could learn more and actually share that with our clients. So with that, Thomas, I'll turn it over.
Thank you, Sherry. Thank you, everyone, for taking the time out of the afternoon to come in. I normally like to walk around, but we're videoing this, so I have to stay in this little spot right here. So if anybody sees me wandering, just kind of throw something in that direction so I don't go any farther, of course. The topic today is scan, capture, win. And while it seems like, well, yeah, we've all been scanning into whatever format we've been doing for a long time, there's a lot of things that haven't been done. There's a lot of areas that haven't been covered for scanning, and there's a lot of really crucial areas for the law practices today that that you may not be aware of, and we want to talk a little bit about what's going on. See, look at that. I just almost wandered off there. All right. So you heard a little bit about myself. I've been in the consulting industry for over 20 years at this point, and I've been with Canon for about 3.5, and that's enough about my work stuff because this is the fun stuff. I'm originally from Seattle, as Sherry mentioned, so I like to make sure that everyone knows that. I'm not a New Yorker per se. I live in New York now. I moved out there on a whim when I was younger and met my wife and stayed. I have 3 kids, Jack, Derek, and Haley. They keep me very, very busy, and it's always loud at my house. There's no way that anybody can hear the echo dot that's in my house at this point. Anything with 2 wheels, I'm really in for it. So I currently have 2 motorcycles. My wife is really not happy about that. She'd like one of them to go. And I grew up a Seahawks fan. So that's me. And the one in the middle, she kind of like gets the most attention sometimes, but I suppose fathers would understand that one. So that's a little bit about me. Jumping right in. Canon as a trusted partner, just a little bit about our background. 41% of law firms have Canon as predominant photocopier, and that's via the ILTA survey. How many people are ILTA members here? Just show of hands. I thought I recognized you from ILTA, wandering the halls there. Okay. For the last 14 years, Canon has held the #1 spot in the legal industry for providers. We also, in A3 and A4 monochrome and color, in the top 3 positioning in all those categories, #1 in black and white, and #2 in the color copier. So we're historically a trusted partner within legal, so it goes without saying that it's a solid product. It is very functional and capable inside the legal space. And that's enough sales pitchy for me. So really quickly, everyone knows that there's tons of paper still going through legal, and it's not necessarily the fault of the law firms. It's just the way the system works and the way that a lot of clients bring in their materials. What we want to talk about today are the 2 different aspects of that: the content that is business related, and then also the content that is personally related, PII, personally identifiable information, which has a big impact on what's happening to firms and what's going to happen next year. And I'll talk about that in a minute. So these are the key areas that I want to talk about. I feel that they're very linked. Oftentimes you can break out of the information governance, you can break out security or compliance. I bundled them together to keep it simpler, but the reality is these are key areas that, whether you know it or not, are tied together when you're talking about the content and document workflows in a law firm. One that you may not be used to seeing is user adoption. My years as a consultant taught me that there's a lot of solutions out there that are really great solutions, but they end up on the shelf, and that doesn't hurt any administrator or IT department when you've purchased something and have to explain 3 years later why that expense sat on the shelf and gathered dust. User adoption is a huge issue within the legal space. Inside, say, the adjacent space of financial, you don't have the same issues. You can force them. You can force all the users to do it the way you're supposed to do it. And you can't do that in legal. You have a lot of different things that are happening. I'm not telling you guys anything new, but it's a key area that it's something we want to look at every time we're looking at a solution that might be proposed or brought into your firm. Productivity is a big one. Everyone talks about it, but what areas are impacting productivity? I'll get into that. Expense management. Everyone talks about cost recovery. I'm really tired of talking about it. AFA is the one that I'm interested in, and in particular, business intelligence. I really think those two are tied together, and long-term, it's really important for firms to understand what it's costing, what's happening inside the workflow, understanding the different pieces that are happening, the metrics that are coming out of that, and what are you doing to help yourself and your business forecast for the future. So jumping right in, information governance, starting off with security. 1 in 5 law firms have reported a data breach. That's 1 in 5 that are reported. That's not 1 in 5 that ever. Some speculate that the number of breaches is closer to 75 to 80%, maybe higher, but they're not reported. Is everyone on the ABA site following the cybersecurity reports that they're working with the FBI, and hopefully you're seeing those and you can keep track of those when it comes to applying those updates and understanding what attacks are happening out there, what actors are involved. Root causes of data breaches. A lot of times people think it's, you know, simply a hacker, but it's not. Malicious or criminal attack takes the lead, but human error factors into this quite heavily. And that's why I want to talk about this in talking about scan capture. Capturing things in a easy to use way, getting users involved in it, getting that user adoption ensures that we're not having the same sort of problems you might have actually had you given those users the free rein to do it however they wanted to. The ad hoc processes, the undocumented processes, those kind of things all add up to the human error that accounts for 27%. Security covers a lot of different areas, but the access to sensitive content covers a compliance area as well, as we'll get into in a minute. The overlap there is covered under the custodial controls, the control of routing or distribution. Do you have records of where it went, when it went there, who had access to it? If you can't do that, your best case scenario is you get an audit and you have to go through that painful process to defend yourself. We want to make sure that we're getting things scanned and captured in easily and recorded in every step of the process. And that means that you have to vet your vendors. And that means vetting folks like us, coming in and taking a look at our solutions with a very critical eye. 80% of firms are not vetting their third-party vendors for security practices. That's significant. I know as a consultant, there are vendors at your door day and night trying to get your business. If you're not vetting them, how do you know that when they take and handle your materials that you're trusting them with, that they're handling them the same way that you would for your client? Are they giving it the same trust and respect? I can say that having been out in the field on the other side of the fence, I doubt it. They're going the cheapest route possible. They're getting the cheapest labor possible. And the idea is that if we can't manage those vendors, that's the weakest link in this whole chain. 63% of breaches are linked to third parties. So that's significant. So you've got 80% that aren't even vetting them. You got 63% of them that are coming from those 80% that aren't vetted. 34% of firms reported getting a client data and security system audit in 2016. It's expected to grow to 50% by 2019. That is significant. Getting an audit is painful. It's very similar to getting audited by the IRS. You've got to go through a lot of paperwork and prove and defend yourself without a doubt. It's a lot easier to do that when it's not a paper trail, when you have electronic records of how everything was handled at every step of the way. So jumping right into the most recent security issues. I'm sure that you might have heard about the Panama Papers and how significant that was. It's the largest data leak or breach in history so far. Appleby this last week announced, and that came out in the news, that is coming in a close second. And the average total cost of a data breach for a U.S. business in the professional services category that law firms land in is $4 million. That is immense. And when I start talking about how we look at the amount of records and the amount of data that's dropped into one of these firms and pulled out in a breach or a leak, it's incredibly scary when you think about the cost of per record. $221 per record is the average cost for professional services like legal in a breach. That's covering the expense of churn. So 5.2% of that expense, it revolves around trying to retain or gain new clients again because you've lost them due to the breach, due to the lost reputation of your firm. Do you think anybody's going to go down to Mossack and Fonseca and ask them for their services anymore? I doubt it. They're going to be working really hard. I bet that 5.2 would be a dream for them right now. The same thing goes for Appleby. And under that scrutiny in the public eye, you don't want to be there. These are the known ones that are pretty high profile: DLA Piper, Gravatt, Weil Gotchel, Wiley Rhine, and 39 Essex I wasn't familiar with, but they were apparently taken advantage of about 2 years ago. These are all firms. They're not small firms. These are significant firms in the marketplace that have been breached. They're estimating that there's about 1,000 attempts per hour against any firm's network firewall. That a lot of them, if you don't have intrusion monitoring, those attempts gone unnoticed turn into real events in the long run, because it just takes so many times swinging the bat, you're going to eventually hit the ball. And they keep hitting, and they're going to get in your firewall. If you don't have something in place, you don't have the mindset behind it to protect the content and the data the way your client would want it protected. They're giving you the most sensitive things. They're not giving you the doodles from the last meeting that they had. They're giving you their sensitive content. And we're being held to protect it the same way that they would. So in perspective, the world's biggest data leaks. Again, Panama Papers being the largest. Second comes in the Paradise Papers, and then going down all the way into the WikiLeaks, which seemed like a bigger thing, but then when you look at the immense size, that's tremendous, and the number of records. I point out this map. This was the Applebee's client list map that's a BBC had done. And I point this out as we go in and look at the compliance requirements that are going to be coming down the road from Europe, and they're going to be impacting us. Start thinking about this. If your firm is working with the data that belongs to a customer or a client that is personally identifiable information and you get breached, you're going to be liable. And it's likely you're going to have people in your list. And it doesn't take much. The information that the GDPR, which I'll mention coming up, is very granular in the amount of detail that they look at. It's just anything that can identify you personally. And having something out there, the cost of a breach is going to be significant. Compliance, as I mentioned before, we've got HIPAA and GDPR, the two big ones out there. HIPAA, I hope everyone in here is aware of the HIPAA omnibus and what that means for law firms. Everyone's good? Yes? Okay. That's a big change in 2013. Just the fact that you're now a business associate instead of being a third party who can simply handle their information because you're a trusted confidant. GDPR, and I'll talk a little bit more about this in a second. Really big event that's happening May 25th of 2018. It's going to change the way we all handle the materials and that we're entrusted with. We want to have that defensible audit trail, because if you have a breach, you want to defend against it as quickly and as thoroughly as possible without having to dig through boxes of paper to do that. Having physical storage can create a lot of risk for your firm. A lot of firms still rely on paper. The partners like to keep all those materials in their offices indefinitely sometimes. I've seen them stacked up. I've walked through enough large firms that it's crazy that there's not a fire that happens sometimes with the amount of stuff that they have stacked up in there. And there's a risk of loss. There's no way, no accountability, no tracking that. Do you know who walked in that office? Do you know if the cleaning person didn't walk in and see sensitive materials or pick it up, or if it's even lost and how long it's been lost? You don't know. We want to get it into that scan capture process, and that's why it's really important to start doing it early and often. The ad hoc processes, unmanaged sharing, letting your users have access to content outside the walls or outside a managed process. It's a big problem. I do it in my own job, but it's on record now, but I've been known to use box accounts, Dropbox accounts to share files back and forth with peers and colleagues because I don't want to cloud up my email inbox. But that's poor business behavior, because now that document, that content that's sensitive is sitting out there in a consumer grade box or Dropbox or Google Drive account that has no track record of what I did with it, when I did it, who I gave it to. There's nothing now. It's as good as being paper and left at Starbucks. So it's almost worse to allow them to have access to make those kind of decisions. Small firms may do it because it's just a matter of convenience. Larger firms do it because it's a matter of we can't control the partners and their behavior. But the reality is the costs are significant when it comes to the pain that's associated with losing materials. So we all know about HIPAA, High-Tech Omnibus 2013. That really changed things. GDPR, that's the big one. Has anybody in here not heard of GDPR? I know I'm putting you on the spot to raise your hand. May 25th of next year, the penalties are enormous. Since everyone is good with the HIPAA Omnibus, I'm going to skip this so we have a quicker route back to the snack table in a minute, so if you don't mind. You know the penalties on this one. It's not that bad. I will mention though, I'm not worried about the 1.5 million at the worst. That should never be a firm's worry. That's a slush fund. That's not a big deal to most mid-sized to larger firms. However, the amount of records that are generally stolen inside of a breach or a leak that contain personal information that could contain healthcare information that would apply to the HIPAA Omnibus and next year into the GDPR, that's a class action waiting to happen. And it's going to blow up in somebody's face, and that's going to be the big eye opener. And that firm is going to be hurting big time because now they're not going to be trusted with information again. Class action is the one that scares me on that one. So what is GDPR? Everyone's familiar with it, so we can rush right through this. General data protection regulations. Comes out of the EU. Is everyone aware that this does not just affect EU businesses? The European Union is putting this out, but it applies to all of their citizens' personal information. So if you are a citizen of the EU and come May 26th of next year and a law firm in New York happens to be handling your personal information, gets breached, and they don't follow the recommended guidelines for handling a breach quickly and expeditiously, and that you can show that they didn't, there's a gigantic fine and then a suit that comes with that. So it's significant. And that's what I was just talking about. Why should businesses care? This is the big one. Penalties start at $23.6 million. That's the starting point for it. Or 4% of annual revenue, whichever is greater. They specify that, whichever is greater. So your bare minimum is going to be 23.6 million for a significant infraction. That means that you willfully basically said, I don't care. I'm just going to leave these documents out there. No big deal. I don't care about it. There are smaller infractions that come before this. However, this is the major one that if a lot of law firms haven't gotten on their game and put their processes in place, which if they're not vetting, that's part of the process. If they don't know where the content is going, if they're using an outsourced legal or litigation services, and you're not vetting them and 80% aren't, you can't tell me they're going to be ready by May 25th. That's a big, big problem that many law firms aren't getting in front of. And when does it begin? That's not a big secret. May 25th, 2018. Most impacted business should have been adopting compliance processes already. If you haven't, it's really late. I used to work in IT. I know how long it takes to roll these things out. This should have been started when they told you in 2017 in May 25th. They gave a full year of this. It should have been done already. Oops, I'm sorry. Click too fast. Where to start? And my recommendation is start with the records room, work your way backwards, start cataloging every step of the way, every touch point of a document content that enters and leaves the firm, even if that means leaving to that litigation outsourced firm. You need to know who's handling it, when they're handling it, how they're handling it, why they're handling it. All these security measures that you would normally put on your own content, they need to be documented now, because the minute you start documenting it, you're going to want to get yourself a compliance specialist to come in and help you build a program that fits your firm, that fits the needs of this. Oh man, I just clicked too many. Yes.
Tell concerned if I am a U.S. law firm with an EU, with a European Union rule.
The European Union will come after even external entities as part of the agreement.
So
And
I'd have to have a client that is in Europe or may travel to Europe or may.
no, not travel to Europe. They have to be an EU citizen. However, everyone may be thinking Brexit. Don't worry about London, they're fine. No, they just built a sister program to this to marry it right up to the GDPR. So London's on board with this, following the same program. But we have an agreement that marries into this because of our previous safe harbor agreements that kind of went poorly. There's now an agreement with this new GDPR that they will pursue businesses outside of the EU and inside the US. And we will allow it. So, top ways to save money before a breach: build an incident response team. Running around like chickens without your heads cut off is not helpful, and it will cause significant slowdown in your ability to respond. When you're talking about the GDPR, the other thing that they have to be able to respond is you have to notify the authorities and the person who was breached within 72 hours. So that's tremendous when you're talking about an IT department struggling to figure out how to close the gates that it just got broke down, much less figure out who is attacked and then notify them, and notifying the authorities. So an incident response team in advance helps you build that plan before you have the problem. Extensive encryption. There's no, in my mind, there's not enough encryption in general. And employee training, making sure that the employees understand the policies, the procedures, and that they are abiding by them. It's not enough to send them like they do me at my job. They make me watch videos every 6 months, and I basically click through while I'm watching something else. But the reality is the employees have to be on board with this. We have to find ways to get them engaged and actually following the rules. Encrypt at receipt, encrypt in motion, encrypt at rest, and repeat, repeat, repeat. Every step of the way when you have a piece of material is encrypt. Get it into a digital format. When I mentioned earlier about the ad hoc processes, I really hope everyone is sending their content to an actual vetted internal document management system or ECM system, because while paper may seem less vulnerable to a cyber attack, it's a lot easier to document and have a audit trail that's defensible if you actually have it in digital form and you're putting in a repository that is built to withstand a cyber threat. It's inside the organization. Otherwise, your users, they're going to find a way around it. They're going to send it to Dropbox. They're going to send it a Excel spreadsheet. Can be 1.5 megs, tiny little thing, can have 4,000 records of people in there at $221 a record plus a class action. That's big. So get in front of this. Give them a vetted solution that helps them be productive and doesn't slow them down, because they will find ways around it. I do, and people around me do. We always do. But that's not good behavior. Top ways to spend more money after a breach. Hire third-party consultants after the fact. Significantly more expensive when you're in a rush. You really can't do a vetting process. You really can't do an RFP on that. You're taking the first best bidder that walks in your door, and you're paying it through the nose for it. Do an extensive cloud migration on the rush. Just try to get yourself out of the deep end, and rushing to notify your the people that have been breached, because you're obligated to do so under both the Omnibus and GDPR. That's going to cost you a lot of money. Getting in front of the problem, like I mentioned, user training. So just have to. They have to have buy-in. You have to have them understand that they are also partners in this business. Many of them literally partners in this business, and it's their money that's going to go out the door if they have a breach that significantly costs them in both penalties as well as a class action, as well as the churn that's going to cause when they have to find new business because no one wants to go to that firm because they were just on the list of firms that were breached. They're in the news. No one's going to bring their business there. So it's a lot easier if you can get your users involved in understanding this is their money on the table, not the business's money. It's their money. It's their potential money next year. We never know when a breach is going to happen. There's a lot of materials out there. I like to point towards the SANS and NIST and COBIT. These are resources to help start understanding what the ideas are behind building an infrastructure that can respond to an audit, that can provide a scope for or a framework for securing your content, having an audit trail of your content as it comes and goes. Your clients expect it of you. You have to expect it of your people internally too. Why invest? And I mentioned why invest in this part because when it comes to security and information management, a lot of it, security, the bulk of it, budget-wise in law firms is allocated to the IT department. Not to say the IT department can't do it. The IT department should have an aspect of it that is dedicated to IT security. It's not just a, oh yeah, that too kind of job. The IT department really needs to focus on this. It's, as I mentioned before, the potential for losing a lot of money, a lot of potential revenue is tremendous. And if the firm doesn't believe that, it's like not paying your rent for a year. You're gonna feel the effect. If you don't pay upfront to make sure that you have the systems in place to protect the content, it's going to be costly down the road. It could cost the firm its reputation long term. Expense management, jumping right into this. I know everyone wants to get right out to the snacks, so I don't want to put anybody to sleep before we get there. AFA is really on everyone's mind lately. The last, 6-7 years, it's been kind of really taking off, and everyone's kind of thinking, okay, this is happening. What are we going to do about it? 81% of firms know it's going to happen. Microsoft announced in July, their head of counsel said, we're switching. All of our law firms that support us, they're going to have to provide AFA model billing instead of hourly now. We're not going to accept that old model anymore. Microsoft decided that they picked the top 13 list. These are the firms that are on board with this. If they're not doing it, they're going to lose money. Why does you're probably asking, what does AFA have to do with copiers? It makes no sense. For me, it has a lot to do with copiers. If you don't know the cost of what it takes to do your business, if you don't know how much it costs to make copies, to print, to send things to scan, how much time and effort is involved in that, the aggregate is where it's important. The long term, how much is it going to cost? Because when you start trying to build an AFA model, you're going to have to do some forecasting to predict based on project type. And that's what it's all about. So if you can't do a prediction on this, you're going to be throwing money out. And historically, we've all done cost recovery, right? Because we wanted to get every penny for the project we were working on. Well, if you don't have a historical record and a client comes in and says, give me AFA model pricing, you can't do a bill that's even accurate. You're guessing. And it's not transparent, and that's what AFA is supposed to be. It's supposed to provide some sense of transparency. That's what Microsoft pointed towards. One of the comments that he made actually to that end was that, yeah, it may cost us more to go with a higher priced firm, but it actually cost us less long term. We've looked at the numbers because we have transparency into it, and we can make better decisions about how we're spending our money on every individual case, who's working on it, how they're spending their time. Everything that we touch, we have metrics that come out of this. That's where these two are tied together for the AFA. I really want everyone to understand we can pull those numbers in, we can start collecting them. Even if we haven't done it to this point, we want to start collecting that information so that when you're tasked with provide me an AFA model project plan and cost estimates, it's within a reasonable margin of error, at least within 10%. If you're not, you're in it. I've walked into too many large firms as a consultant and asked them when we were doing RFP bids, tell us how many printers you have. Was the response. We might have a spreadsheet someplace that was hobbled together over time. They had no idea how much volume was going through the firm, how many pages were being printed, how many pages were being scanned. They had no idea how much this service was costing them other than the check every month that went out the door. And that's not going to work under an AFA model. You don't want to miss out on those client opportunities by not having this information and being able to budget for that. If you're in the IT, if you're in the support group, if you're in the administrative groups for the law firm, this is going to come back to you. They're going to ask the firm administrators, the partner who wants to get that deal is going to say, okay, give me some transparency on what these billing costs. And you're going to say, it's not going to work. We need to have that information now, and we can do that. Let's get in front of it. I really think that leads into business intelligence. It's also part of helping manage the fleet that you have, whatever many devices you have, understanding how much each copy costs. Too many times I walked into an RFP and the law firms just didn't know how much they had, how much it cost, what the value of it was. There's a couple firms I'd walk into and I felt embarrassed to be in the field because I'd walk behind some other deal that had happened 5 years before, and you're looking at equipment going, you've used 3% of its capacity for the last 5 years. What brilliant sales guy sold you this? They've sold them a fleet of Ferraris, and all they really needed was a walking stick. You know, it was ridiculous. If you don't know, you can't go in an RFP bid and bid competitively. You're getting taken advantage of. That's where understanding the metrics, the cost of doing business is really important to a law firm. It's not about us trying to save you money. It's about the firm having best practices and taking care of itself. Any questions up to this point? No? Seahawks are good? So I'm just making sure you're awake. All right, productivity should be pretty easy. Content integration, making sure that the ad hoc processes don't weigh you down. If you can't find those materials quickly, if a partner leaves, do they take everything with them? Do they take all that knowledge work that you paid them for with them? Do they take anything outside the walls? If you have an ad hoc process, you can't manage that. So we want to make sure that we're putting structure in place that supports the work that they want to do. Getting that content to surface quickly, the vital information, not just a room full of boxes or a hard drive or 5 hard drives full of information that they have to OCR search. That's not realistic. It takes forever. They're going to get 1,500 results for one search. What we really want is a DMS or ECM system that can really surface the vital information that they're looking for. And that helps them get to the answers that they're looking for faster. Oh, that's my favorite little picture there. Data, information, presentation, knowledge. A lot of people are stuck down here at the information stage. They think that that's what they're getting when they get the OCR. That's good enough. It's not. Having the knowledge based on compiled and looked at that information is really key. Performance controls. Again, fleet intelligence, understanding what you have in your fleet, understanding what it costs to do your business, understanding where the documents are going. All this is integrated. So all the security mechanisms feed into the metrics database. All of the resource allocations feeding into that database. It's a centralized control. It allows you to immediately respond to an audit or a security threat and saying, I know where my content is at. I know what happened to it throughout the course of its life cycle within my purview. It puts you at a better defensive position when it comes to the eventuality that if you think about how many firms are being attacked just broadcast every day, it's going to happen to every firm eventually, even if you don't know it. It's better to be in front of this and have an informed plan. And collaboration, please get it into a DMS. Hopefully everyone here is using a central DMS or ECM system, and you are allowing your users to use that to access it remote, managing the remote access so that they're not sending it to their tablet, they're not putting it on a flash drive, doing all the bad behavior that I probably do at Canon all day. But the reality is we want them to get to that information quickly. We want to support the work they're doing easily. We want to make sure that the content is brought into it and sent to a repository that makes sense. I'm not advocating any particular repository. They all have their benefits. They all have their negatives. The reality is I just want to see firms doing it the right way so that they don't hit these walls of where was that information? Well, this guy uses Dropbox. Oh, this guy uses Google Drive. How do you track that in the event that you have to respond to a breach or a compliance audit? You can't. You're going to be on the hook for that one. And my favorite, the adoption challenge. It's not to adopt kids. It's just making sure that the users are actually using the solutions that they are given. It's number 2, the 2016 ILTA survey in issues. And we all know why. If you work in a law firm, you know why this happens. You have the partner who decides he wants to do it one way, or his administrator decides she wants to or he wants to do it in a particular way. Well, that's what happens. You don't get to say no, they just do. But the reality is it's costing the firm long term. It's the bottom line that's going to hurt them if they have to respond to an audit or a security breach. This culture of resistance, it has to change. You can't force them to do it, but what you can do is use the carrot method and actually guide them to the water and saying, look, it's better for the business. We're trying to help the business long term. This is why we put locks on the front door. Those locks don't make us a zero bit of money, but the reality is we put locks on the front doors. At night, we turn the key, we walk, and we go home. Maybe we put an alarm on. Again, it's not a source of revenue. Neither is, getting your users to actually get involved and use the solutions you have. It's not a today revenue source. It's a tomorrow revenue saver. So when I first joined Canon, I was tasked with, can you build a presentation on how to deliver technology to the 4 different generations in the legal workspace today? And after much deliberation and scratching my head a lot, the reality is, if your solution fits the millennials or younger, it probably fits the traditionalists too. Because if my grandmother can use Google Drive, so can my kids. I'm sorry, Google search is what I meant to say. The reality is they're all doing the same thing. If it's easy to use, that's the key. If you can walk in and it is readily understandable, there is no difference. You're not delivering different technology for each generation. That's nuts. Boomers have gotten, in the last 10 years, have gone from, I don't know if I want to use a tablet, to that's just a way of life now. And that's a big change. We're not waiting for people to catch up anymore. So there is no issue with this. The real issue comes down to user experience and delivering that in the solutions and products you put in front of them. Nobody threw anything. I really just wandered all the way over here for a moment. I like this. If it isn't broken, did you get the latest update? It's kind of like the divergent areas between the ends of the spectrum there. They both bring value in their own way. So this is my little working example of why user experience is important and why you should be considering it. Again, I'm not a salesman. I've never been a salesman. I've always supported them, but I'm not a salesman. So I'm not trying to pitch any particular product. What I want you to do is take a critical look at the solutions that you get put in front of you to bring in, because we want them adopted. We want people to actually use them. We want them to walk in and scan it into a repository that we've vetted and use it in a mobile way that we've said, yes, this is a good, secure way to do it. We don't want them walking away. So if everyone remembers back when Yahoo came out, this is what the screen looked like, if you can zero in on that. It was very cluttered. Then Google came along and everyone went, what? But we know the results now. So then the second thing that happened, 2002, Microsoft releases its first tablet PC. Does anybody in here had one of those? I got to play with one. I was in the IT group at that point and we had a demo. And yeah, that didn't do so well. Prior to 2010, less than 1% of consumers owned a tablet. They didn't even specify the Microsoft tablet, owned a tablet in general. April 2010, Microsoft releases its first generation iPad. Everyone can see where this is going. Maybe you just don't know the actual numbers. Oh, this is where Google sits today. Probably a little bit farther, that was 2015. 44% own a tablet. That's 5 years that took that Apple to unseat Microsoft's attempt back in 2002. Whether it's technology, the reality is Apple understood that the user experience is first. If your users don't want to use it or they find it cumbersome, they don't want to be bothered with the 15 steps behind the copy machine that are taped to the wall, they're not going to use it, or they're going to avoid it. They're going to find another way that suits them, or they'll get stuck in the 15 steps and they'll never want to let go of it. So user experience, that's really got to be paramount. And when you're looking at the different solutions in front of you, take a critical eye, even of Canon. I don't drink all that Kool-Aid. Just look at it carefully. All your solutions to help your business run the best it can. I don't want to see $150,000 solution sitting on the shelf because you couldn't get your users to adopt it because it was so painful for them to walk up and use daily. Just a few things to think about. Using a stick or a carrot, really. What are you doing to help your users get engaged with the training, with the processes, the best practices you put in front of them for security and compliance, and for just simply adopting things? What are you doing? If you put a stick behind people, you're going to find a lot of resistance in law firms. I've seen it fail so many times. They just don't want to do it, and they won't do it. They'll dig their heels in and it's done. But if you put a carrot out there, some reason, some valuable reason when you're putting your campaign together to understand why are we invested in security, why are we invested in a compliance program, because long-term it's going to hurt. It's going to hurt the firm's bottom line if we don't get in front of this today. It's putting locks on the front door, unless you live someplace really safe. And I like this little analogy here. Really, everyone thinks that technology is the key. It's not. It's really delivering the solution to the user, getting users in front of something that makes sense to them, that is easy to pick up and use. UI being the old ketchup bottle, which I think is still kind of fun. If I ever get one at a restaurant, it's kind of fun to see if I still have the knack for hitting the 47 right there. But UX is the squeezy, and usability is the difference in behavior that you see. Users will pick this up a lot easier. My kids wouldn't know what to do with an old Heinz 47 bottle. And again, my kids don't know what to do with a pinball machine either, so they walk up and tap on the screen. It's funny. So with that, I'm going to just quickly guide you towards the solutions. I hope there was enough information in here, not too much. I'm not sure. If you have more questions, please. I took a few slides out to preserve time. These are the areas that I think are linked together, whether people see it that way or not. They really are. Getting content into a resource that is vetted and secure is key, however that happens. But use the machines, use a scanner, and get it someplace and encrypt it through the whole life cycle. And with that, solutions to consider. The eCopy solution, Trish will be demoing over here. Has a lot of the capture capabilities, a significant amount. They've been in the market for a long time. Hopefully everyone's heard of them. Maybe a no-brainer for some people who've been in the industry like I have and forever. But then there's integrated capture with Uniflow, the document scanning. There's a lot of the similar capabilities. Take a look at them with a critical eye, see what works best for your firm, find out what is going to fit, make a choice that way. I don't make a dime either way, so make a good choice. Fleet management and reporting and business intelligence. Uniflow has a lot of great back-end BI capabilities, that can tell you, capture those metrics and report them and consolidate them. Fantastic tool. When it first came out, I want to say I saw it first maybe 10 years ago. It wasn't the complex or all-encompassing product that is now. These are just two aspects of it. That's one of the beauties of Uniflow that I like, is that it has this capability, has the scan capability, has the print management capability, has the fleet management capabilities, all modular capabilities that come into a singular place. So we're collecting those metrics. We're having a consolidated choke point for the content that's going in and out of the firm. And with that, thank you. I hope this was helpful. I hope everyone has some food, some drink out there and enjoys themselves. Any questions?
I was had a question about
Yes.
AFA.
Yes.
Do you have any statistics on law firms that are still doing cost recovery? It seems like I talk to people more and more and they say, oh no, these clients, you cannot line item that at all, the printing or scanning or what have you. I hear that real often, but often enough. Is that kind of going away, do you think? Or what's happening with cost recovery?
I think cost recovery won't go away that quickly. I think it's here that we've become accustomed to that model. I think that the AFA will be a thought leader movement. It's going to take time. Law firms are really slow to adopt things, and their clients aren't going to be wise enough for a while to ask for it in general. But I think the smaller firms, may start seeing some of that knowledge out there. Larger firms were going to get hit because they're just looking for ways to save money. The corporate counsels are. So it may take off in the larger firms faster, but that trickle down, I don't think it's going to change the mid-sized firms quickly.
I was just wondering, like if you have a firm that represents a pretty decent sized insurance company or something, and the insurance company says, nope, not going to pay your fees, but if the law firm said, well, how about if we did your billing in a different way, such as an AFA kind of a model, I wonder if the insurance company would be more open to the fee, the all-inclusive fees, including the print and the scan and all of that. I don't know.
I think, and that's why I brought up the Microsoft thing. I think that when somebody like Microsoft comes out and says this, and says even going with a higher cost provider is actually cheaper, I think it's going to make larger corporations stop and pause and say, oh, really? Let me do some financials on that to understand it, because these cases are expensive and they do them repeatedly. I mean, that's why you have the same counsel over and over again. So it's going to be costly long term. And yeah, I think they are going to get that message out. I think Microsoft set the bar. GlaxoSmithKline is also the pharma that's doing this, and they're like hardcore about it, 100%. Everything's got to be transparent. Everything's got to be project based. I didn't mention that one because I was running out of space in the slide, but.
You said the Uniflow, it tracks when somebody scans something in, who scanned it in, where it gets saved.
Yeah, it has a lot of security capabilities.
Who opens it, it tracks all that.
Not who touches it. So what we are is we're the sort of the middleman through the Uniflow piece. So when that user goes over, they authenticate, they scan that material in, we're capturing who that was, we're making sure that the right person is being tracked. However, whatever method is being chosen at the firm. So is it a badge? Is it a password on the screen? So once that is handed off, I'm hoping that it's being handed off to a DMS system, a document management system, or an ECM system, where the authentication continues there. We wouldn't handle the entirety of that process, because once we hand it off to you, now it's in your realm of security. But I would hope, and I'm really hoping that firms get on board with this. The banks got on board a long time ago. They knew, and plus they had to be compliant. But questions, Tom?
Any other questions? I want to thank Thomas Baker for coming and giving us the seminar. Also,